Hey everyone, and welcome to which will be a kind of a sad video because this is a video where I'm going to read what could be the last pro se motion filed by Sarah Boone. This is filed before she obtains her lawyer and her second lawyer who came forward now. This is a motion to object by the defendant to the state's digital evidence on a USB thumb, not a jump drive, but thumb drive. Blah, blah, blah. The defendant. Objections are for digital context, specifically and only located on the USB jump drive. Don't you call it a thumb drive? I do. The Sarah Boone Digital Discovery Compilation, which was submitted to the defendant on August 9, 2024. Objections by the defendant are as follows. Suitcase videos. These files were obtained from her personal cell phone. There is no video located in this folder on the jump drive. And then she mentions 3 different videos or images. Photograph of suitcase, audio 2 minutes and 3 seconds, audio 22 seconds. Lack of authenticity. There's no one to testify that the pictures and audios are the same as the scene was at the time the audio was recorded and the photograph taken. The prosecutions failed to establish authenticity in any of the 3 items submitted. And then she cites some law. Well, Sarah, this is obtained from your phone with the metadata that is kept on your phone. The authenticity for this will be having the tech guy sit on the stand testifying that he downloaded this from your phone, he verified that the date stamped on it is correct and it is from your phone, and that it still is on your phone. So again, the chain of custody will take care of the authenticity, especially because you admit it's taken from your personal phone. It's not a random phone found at the scene, not linked to you. It is your personal phone. So it's really easy to prove authenticity in this. That dog won't hunt. Potential for unfair prejudice. I believe that the singular reason to utilize this audio is for the state to heavily prejudice the jury against me based on my statements in the audio to Jorge Torres. The prosecution's evidence is more prejudice than probative. And then cites some state law again. No, Sarah. This is to show the jury your state of mind at the time. You made those statements. You cackled like a hyena while that man begged for his life. You prejudice the jury against you by your action. It's not the videos that'll prejudice the jury against you, it's your actions that the jury will use to determine if you're guilty or not. That dog won't hunt. Violation of Fourth Amendment rights, unlawful search and seizure. This audio was obtained by an not awful, search and seizure of my personal cell phone, and the defense moved to exclude under my Fourth Amendment right, supporting case law. Sarah, I believe you signed over your phone. Was it at the police interview or at home? You gave the phone to the police. You're a suspect in this matter. If they have a warrant to search your phone, it's not an unlawful search and seizure. Again, you are suspect in a crime. You are not being stopped randomly on a street with no reason for the police to ever look into your phone. You were at a crime scene. You admitted you put him in the suitcase. That dog won't hunt, dear Sarah. It's not unlawful. Body cams, 4 items. And she mentions 4 different titles. Lack on authenticity all of the body cams, video obtained from the uniformed officers on the date of the incidents are timestamped and documented incorrectly during the entire use while at the crime scene. Florida law. Yes, Sarah, you are correct. We mentioned this while we were watching it because the dates are really off, the times are really off. We couldn't figure out at what time of day because you were supposed to pick up your son, your ex-husband called you. We know kind of at what time of the day it was. The body cams didn't show that. Let me fix the authenticity. I will now be the prosecutor. You, the audience, will now be the police officer. So, officer, you arrived at the scene of the incident. Yes. I can tell that in the corner of your body cam video, it says it was 7 o'clock at night. Is that correct? No. What do you mean by that? Well, my body cam has a discrepancy. So every video it tapes is plus minus 5 hours. So what you're saying is when we see 7 o'clock, it's really 2 o'clock. Yes. Thank you so much, officer. Have you had that verified? Yes. Boom. Out the window. Dog don't hunt, Sarah. I'm sorry. You should watch more LawTube than Matlock because we see it in every case. Just go watch the JDAH. Some of the richest neighborhoods in California still have security camera that's off by hours. It doesn't matter as long as they have checked the camera and said, oh, it's off by 2 hours. Then they'll just testify to it in court and it'll be fine. El Doggo won't hundo. Violation of best evidence rule. The state fails to provide the best version of this evidence under the best evidence rule. The state had not provided true and accurate video evidence, and the defense moves to exclude these body cam videos. Again, what is the best evidence rule you believe they broke? Because the timestamp's off, you will have the officer watching the body cam saying, this is exactly what happened. She was straddling that bush with her alky legs spread, making Danish YouTubers blush. And then they'll get right past it because it's not the time on the body cam that's the big deal here. You have officers who wore that body cam confirming what's seen on the body cam. Go back to the Karen Reed case. Their cameras was off all the time-wise. You just have to testify, yes, this is exactly how I believe it, even though the time zone was off. Again, no dog, no hunt. I'm sorry, Sarah. I know I'm going to miss these pro se litigant letters. It's good content. Violation of Miranda rights. The body cam videos recorded me making statements and providing information prior to me being given any Miranda warning. First of all, Miranda is out the window. It's been ruled on cops don't care and courts don't care. So I know we all know that, oh, you didn't give them their Miranda rights. They are free to go. No, the courts have ruled against it. And secondly, when you are interviewed at the scene, you're not interviewed as a suspect. You're just a witness. Your husband isn't given his Miranda rights either because they are just trying to ascertain what happens. When you arrived the next day for the interview, you are Mirandized. That's why everything you say can and will be used in the court of law. And that's why when the police say, I just want to talk to you, you say, I want to talk to you too when my lawyer is present. You don't go and say, well, I locked him into a suitcase and yeah, I probably did it and think you can get out of it. Miranda has nothing to do with this. Your open, big mouth, talky talk mode is what got you into this trouble. So again, Sarah, there's a lot of dogs who have a day off because this won't hunt either. Miranda is a thing when they pull you in for an interview, but you freely gave them all of the information at the scene. They didn't ask you as a suspect in the case. They were just asking questions. What happened? You voluntarily spoke to the police. It's on you then, Sarah. Just remember that. Oh, these are illegal interrogations and violate my Fifth Amendment rights and should be excluded under the exclusionary rule. No, the Fifth Amendment right is your right to shut up. It's not the right that anything you say won't be used against you. People might need to know about the fifth. The fifth is I'm going to shut up because I don't want to incriminate myself. You gave up the right to your Fifth Amendment when you started incriminating yourself. No one said, hey, Sarah, you has to talk about this. You voluntarily yabbered on. Your Fifth Amendment rights were canceled by your mouth. It's not by an officer saying, what happened? The second you tell the officer what happens, you forego your Fifth Amendment rights because you voluntarily gave them the information. It's not an interrogation. No one pressured you into talking. They didn't say, you better talk or we're going to kneecap you. You talked. Your Fifth Amendment right is guarded by one person. It's you. You should have said, well, officer, I plead the Fifth. I want my lawyer. And then you shut up. The second your mouth starts moving, your Fifth Amendment goes out the window. You can't stop and say, oh, halfway through, I just want to plead the Fifth. No, you can't answer some question and not others. You cancel your Fifth Amendment rights. Defense interviews, one item. That's the video from the interrogation cell. Lack of authenticity. This interrogation video has no timestamp throughout its entirety of 2 hours. Only 01 minutes and 3 seconds. And a best evidence rule. The state fails to provide the best version of this evidence under the best evidence rule. The state has not provided true and accurate video evidence, and defense moved to exclude this interrogation video. And again, Sarah, there might not be a timestamp. Do you know how the police will get by that? They will say, Officer, shiny shirt, were you in the room with Sarah Boone on or about X day at X hour? Yes, I was. I spent 2 hours in there where she told me at least 10 times that she did it. Okay, so you are saying this is a true and accurate depiction of whatever went on in that room? Yes, sir. So this is what I'm going to miss. Sarah Boone totally misunderstanding any of the law, not being. That's again, I'm sitting 7,000 miles away. I have a better grasp on the law than you. You have been fighting your own case for a long time. Sarah, you have to do better than that. And just to end it all, the defendant is unable to utilize her Sixth Constitutional Amendment right to counsel. No, you forgave that by being a-hole to all your lawyers. Has never been pro se before. That's not a defense. Is not an attorney and officer of the legal system. That's not a defense. Lacks requisite professional competency, experience, expertise in the legal field. Well, when you forego your rights, you end up in a bad situation. You were warned by the judge. Is currently incarcerated. Yep. That's, again, your own problem. Has extremely limited and restricted resources to conduct extensive legal research to further support objections. No internet. Well, Sarah, you have a law library. That's how you did it before. That's how you can do it again. And you do have the internet as far as we've been told. You have access to it. Does not have full-time use and access to laptop. You have 8 hours a day. That's more than your lawyer would have wasted on it. Does not have full-time use and access to tablet. Again, the same as the laptop. You're in prison, Sarah. You could just have shut up and stopped harassing your lawyers. You could have been stealing cheese and gloves all day long while they worked on your case. Does not have access to privacy temporary for in-depth review of discovery. You were offered only sell and you said no thank you. Has limited access to defense team, investigators to collaborate and complete greater work product. Again, you have the access, you can call them, ask them to do whatever you need to investigate. Your problem is you're also indigent, so you have a limit on how much money you can spend. So does your lawyer, unless he want to pay the cost himself. These objections was done as expeditiously as possible part of my current circumstances. The pro se defendant requires much more time, especially while incarcerated, than that of an unrestricted, well-educated, resourceful attorney who is fully capable and has all of the aforementioned availability. Also, I reserve my reasonings for my objections for in-court oral arguments. Wherefore, the defendant, Sarah Boone, by way of pro se, respectfully moves this honorable court in conclusion to hear my reasons why I am objecting to the state's evidence against me and to exclude or limit the included particular items attempting to be admitted into my criminal case by the state. Well, Sarah, I will take a wild guess on this one. The judge will rule against it because this is normal evidence. There's nothing special about it. You are not that special little snowflake. You are a crazy person who videotaped you doing something very crazy. And all that evidence will be shown in court. If you're lucky, maybe one of the suitcase videos will be thrown out because there are two showing the same thing. But again, one of them shows that you flipped over the suitcase. You will hear your own cackling voice again in the courtroom, making fun of a dying person. It won't be thrown out. And again, you are not a special little snowflake. You put yourself in this situation by doing a stupid crime, by running your mouth. And when you got 8 different lawyers, you made 4 of them go away because of your behavior. So I will miss our time together, pro se Sarah. Sadly, I don't think the judge will let your new lawyer drop out before court. He can have an appendix problem. But I miss the days where I could read your story and sit here and think, how can one person be that stupid?